Welcome back to the Legal Alternative Podcast with me, Sam Pawson. The eagle eyes of you will see that I'm not joined by Nils this week. I'm honoured to have one of my team, Madeleine Partland, with me. Hi, Madeleine, how are you?
I'm good. How are you?
Very good, thank you. Yeah, it's a bit strange without Nils, but we will persevere. We're going to do it a bit differently today. We're going to have a focus with us both being employment lawyers. We're going to have a focus more on pure employment. So no regulatory this week, Madeleine. I don't think we'll put you through that. So we'll chat. We're going to chat about a bit about the menopause. We've had some quite interesting statistics out of the tribunal. So then we thought we'd kind of update that and then have a bit of an overview of protected characteristics, where we are, and kind of advice to listeners. So I've got some statistics in front of me that you found for me, an update from the tribunal reporting that we have seen the headline term is a 319% increase in menopause claims in the employment tribunal relating to menopause. Pure numbers, that's from a low point of 64 in 2022, and we're up to 204 cases in 25 when the report came out. We've talked about the menopause on past podcasts, but we want to do more of a more detailed analysis today. I think those numbers show the increased awareness, but also there has been some publicised cases. So I think that has also driven some awareness that you can pursue, obviously based on the menopause. For the listeners, Madam, do you want to talk through the kind of key considerations where we are with the menopause in terms of, is it a protected characteristic, isn't it not a protected characteristic, and what kind of protections there are?
So, as the law currently stands, there's no formal protections that recognise menopause in the law. However, just because menopause itself is not a protected characteristic like race or sex, it is still protected. We have had some attempt to kind of make it a protected characteristic. Back in 2022, the Women and Equalities Committee recommended that we have a 10th protected characteristic, and that was being menopause. Their kind of aim was that they wanted to provide a clearer legal framework for employees who were experiencing menopause to know that they had protections. But actually, their recommendation was declined by the UK government. So the UK government said basically what I'm about to, in that whilst we don't have a protection explicitly for menopause, within the law as it stands already, we do have existing protections under the characteristics of sex, age, and particularly disability. So their recommendation was that there's no actual need for it because it's already there. So this means that whilst there's no specific legislation that specifically protects people going through menopause, it is legally protected indirectly. So it's still really important that employers comply with that legal duty. In terms of where that protection is, we're looking at sex, age, and disability. So sex is sort of semi-obvious in that menopause only affects those who are assigned female at birth. So if you're treated unfavourably because you're going through that, it may be sex discrimination. Similar with age, although slightly less so because some people can go into menopause early, is that as menopause typically affects women between the ages of 45 and 55, it can constitute age discrimination. But the big one, the one that's kind of attracted media headlines, is disability. So as we saw in quite a highly publicised case, which was M. Davies versus Scottish Courts and Tribunals, menopause can amount to a disability. So menopause is not in and of itself a disability, but under the Equality Act, if something has a long-term substantial adverse effect on your ability to carry out your day-to-day life, it can be a disability. So if those menopause symptoms actually have a severe impact on that employee's quality of life day to day, and that effect is long-term, which it is likely to be, it could be, and this tribunal case proved that it can be a disability. So sort of in that case itself, Miss Davies experienced severe menopausal symptoms. So she had heavy bleeding, emotional distress, fatigue, and cognitive difficulties. And these symptoms fundamentally affected her ability to perform her duties. The tribunal ruled that her symptoms did amount, in this case, to a disability, and that she'd been treated unfavourably as a result of something arising from that disability, which is something that we'll touch on later. So in terms of what that case established, was that it established that whilst menopause is not inherently a disability, so you don't necessarily need to treat an employee who may be going through the menopause as disabled, it can be.
And for me on that point, it's the key in terms of the language that clients and listeners need to be aware of. It's that substantial impact. And that's where I think, obviously, in the case of Davy, so as you said, like, the symptoms were very severe. I think the slight grey area and concern going forward, if there is a case where the symptoms aren't as severe, but still have an impact. And if there is a case it's decided, well, it has an impact, but it's not that substantial impact, that will be where I think you might see, back to the original point, of more pressure to have it recognised as a protected characteristic of its own. Because ultimately, if the law gives protection to someone who has menopause, that's fine. That's what the position is. It's where that would fall short. I think there is going to be a challenge. In terms of duties for employees, and if we are being qualified as disabled, reasonable adjustments usually a critical one for companies to consider. Do you want to quickly talk on that?
So yes, so under the Equality Act, employers are required to reduce any disadvantage that's suffered by an individual with a disability. In terms of menopause, this could be a physical adjustment, so it could be allowing an employee to have a fan, or it could be changes to their working patterns. So it could be if they're having difficulty sleeping, as often women suffer with that during the menopause due to night sweats, it might be allowing them to start slightly later in the day. So it might be a 10 a.m. start versus a 9 a.m. start. You also might suggest things like remote work, or other adjustments like adjusting, like I said, start and finish times, allowing more frequent breaks, relaxing the uniform or your dress code policies, ensuring that women going through the menopause have access to toilets and facilities, and potentially providing rest areas. And this is likely to depend heavily on the symptoms suffered by the individuals. Some of those adjustments may not actually be reasonable or even necessary for women experiencing certain symptoms. But what we have seen in the tribunal is that failure to do so and to make those adjustments can amount to unlawful discrimination. We saw this in another case in 2023, which was a Mrs. Linsky versus Direct Line Insurance. Mrs. Linsky, who was a telesales consultant, did experience, again, those significant menopausal symptoms. So she experienced low mood, anxiety, mood swings, memory issues, poor concentration, and this ultimately had quite a severe impact on her performance and her ability to meet, in this case, performance targets, which were set by the respondent. However, the respondent didn't recognise that this would have had an impact on her ability to meet those targets, despite her making them aware that she was going through the menopause. So the respondent continued to apply those standard performance management expectations and actually withheld a pay rise from Mrs. Linsky as a result. They also did other things like she had an occupational health report which recommended refresher training, and they refused that. And they ultimately withdrew sick pay, as they said that her absence, which is something we'll come to at the next point, that we often see with menopause, was unsustainable. But the tribunal ultimately found that under the Equality Act, the respondent had failed to make reasonable adjustments. It suggested some of those adjustments could have been adjusting those performance management targets to reflect the impact of her symptoms. I think, interestingly, you don't need to completely remove performance targets, but it may be appropriate to amend them. They could have allowed more flexible working arrangements, and in general, they could have offered additional support rather than putting her through that performance management process.
Absolutely, and we've touched on a link to this, and an issue that we advise on a lot, and I get issues, is about absence. And when we have, with any disability really, but one that is caused by menopause and those severe symptoms, where we're seeing a greater degree of absence. We've touched on Section 15 claims. Do you want to talk through that and what we're looking out for there?
Yes, so under the Equality Act, under Section 15, it's unlawful to treat someone unfavourably because of something arising from a disability. Something arising can be sort of any sort of symptom, but one of the things we often see is absence. And if menopausal symptoms are requiring women to take time off work, this is an issue that we are seeing. In this instance, the big one that we get that's an issue is if an employer disciplines an employee for absence or puts them through a performance management process without appropriately considering whether menopause is having an impact on that absence, you can potentially be treating that employee unfavorably. This doesn't mean, and we see this in practice a lot, that you can't put someone through an absence management procedure. If ultimately absence is unsustainable and it doesn't support the needs of your business, you're not required to go to the ends of the earth to support that employee. But it does mean that you need to consider mitigation and consider the circumstances. So in terms of managing that, we would generally advise to manage that very carefully. In terms of best practice, we would recommend that employers record menopause-related absences separately to non-disability related absences. We would generally advise against employers using automatic absence disciplinary triggers. So that's when employers you've reached X amount of absences, we're now commencing disciplinary action. And we would also just generally, which is kind of covers the previous 2 points, advise that they apply any absence management policies sensitively. In terms of a tribunal case on this one, whilst we also saw that in the Linsky case, we saw this in another case, which was Rooney versus Leicester City Council. Maria Rooney, who was a social worker, again, those severe menopausal symptoms, including, in her case, anxiety and depression. This led to her taking quite a prolonged period of absence in 2017 and 2018. And despite the council being aware of her condition, she was ultimately issued with a warning and she did ultimately resign. While she wasn't initially successful, interestingly, in the employment tribunal, the employment appeal tribunal held that her symptoms could amount to a disability. And that in that case, the something arising was, as we've discussed, sickness absence. So that they ruled ultimately that issuing her with a warning was treating her unfavorably because of that something arising.
And really sage advice there again, just to kind of consider those processes and anyone using Bradford factor triggers like that to really look at that and to always look at mitigation. Discounting those absences is for me an absolutely fundamental one. So very sage advice, Madeleine, really helpful advice. In terms of for listeners and our recommendations, key ones as always you'd expect from an employment lawyer is look at your policies. When I last did an event, I think we did a hands up on who would have a menopause policy, and it was still only probably a quarter of the room. So again, for listeners, if you don't have a specific menopause policy, we would recommend that you get one, and we will obviously be there to assist in doing that. It's key that menopause policy always talks to your other policies, so it needs to link, as we just talked about, to any performance management. It needs to link to any absence management policies, so they all talk together. Again, as you said, the best advice often is sensitivity here. So be available to speak to your employees, give them that sounding board to support them going through that. How do you do that? That can often be through better awareness in the company's training. So again, if we can demonstrate we're training staff on that, we have a policy and we're dealing with issues sensitively, I think I don't know if you agree, Madeleine, that will do half of the battle here. And then it's case by case. Is it a disability? If so, do we need to look at reasonable adjustments? Do we need to consider changing our policies? Any final thoughts from you?
I think it's kind of important to remember that even if potentially menopause isn't protected in this case, particularly as a disability, it is important in terms of supporting your employees. So just because an employee's, maybe their symptoms aren't severe, maybe they haven't lasted a kind of material time for a long period to the point where a tribunal might not rule that they were, for example, disabled, it's still really important, first of all, from a legal perspective, but also in terms of retention and actually supporting your employees, that they feel that they are being supported in the workplace. The difficulty we have with menopause is that it primarily affects women who are often at the peak of their careers. So like we said earlier, it tends to affect women who are between the ages of 45 and 55, which is often when women are actually reaching positions of authority and reaching kind of the pinnacles of their careers. So it's really difficult for a lot of those women to feel supported in their workplaces. And we are seeing from the statistics that a lot of women don't feel supported at work, and are actually up to sort of 15% of women are considering leaving work because of those symptoms. So even if I think there's not a legal duty necessarily to support those employees in terms of retaining your best staff and making sure that they feel supported and attracting talent and retaining talent, I think that's still, regardless of the kind of specifics of whether it qualifies as a disability, it's really important to have that awareness there and that training piece and that support available.
Couldn't agree more. Very well said. So a bit different podcast this week. So deep dive into those menopause issues. I hope everyone has found that as helpful and as enlightening as I have. Nils will be back next week. So big thank you to Madeleine to stepping in. I hope it wasn't too daunting, but you were back in your ears and on video next week. And a big thank you for me.